Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Craig Martin. Craig is a certified financial planner. His company is the Family Wealth Consulting Group. They are fee-only financial planners and provide asset management services. They've been doing that for over 30 years. Craig is the author of a book, Craig Martin, on asset class investing, and I'll bet if you got in touch with Craig, you see his address, contact information at the end of this show, he would love to send you an autographed copy.
Be happy to. Thanks, Mike.
You're welcome. And so today, we've been having people going through turbulent times. We just did a show about that. You might want to look at it on our past episodes. Should be posted at our website, financialinsiderweekly.com. But the person, or a person, that I think people should be depending on to help them out through turbulent times is a fee-only financial planner. So today we're going to be talking about what is the role of a fee-only financial planner. Craig, thanks for joining me and being my guest today.
Mike, I'm real proud to be here. You have created a real legacy of recordings of some of the best minds in the financial industry in our community. Yeah. So congratulations on what you're doing. I'm real proud to have been a part of this list.
Thank you so much.
Yeah.
And I'm proud to have you as part of my list.
Good.
All right. So let's get on with our first question. Craig, what is the difference between a fee-only financial planner as compared to a stockbroker or a fee-based investment advisor?
Well, since I've done both, maybe nothing. I'm the same today that I was, but what I can do as a fee-only financial advisor versus a broker is a lot more than I could as a commission sales-oriented broker. So the fee-only financial planner is about advice and counsel. Mm-hmm. Everyone in our firm has a master's degree. Our business is education. It's not selling a product. Mm-hmm. In contrast to the brokerage world, you would think Merrill Lynch, Dean Witter, Edward Jones, those kinds of organizations, they sell a product. The person who works at that firm, the salesperson who works at that firm, sells a product and earns a commission. Mm-hmm. Now, there are several kinds of licenses to be able to work in this business. The license to sell a commissionable security is called a Series 7, issued by the FINRA, Financial Industry Regulatory Agency. And FINRA's number 7 license says that the salesman can sell a security and earn a commission for it. To be able to sell that security, they only have to, quote, know their client, mm-hmm. which means name and address and date of birth maybe. Mm-hmm. In contrast to being fee only, I gave up my Series 7 license 20 years ago. I can no longer receive a commission from the sale of a security. Mm-hmm. I now have what's called a 65 license from FINRA. That 65 license says that I can charge a fee, but I cannot receive a commission. Mm-hmm. So we charge a fee for the amount of work that we do or the amount of assets under management. We basically work for the client. We don't work for the brokerage organization selling products.
So there's not somebody that's your manager. Of course, you're in charge of your own firm, so I'm being a little facetious, but it's basically saying, get on the horn and call your clients and tell them about this particular new offering or what have you. That's
pretty standard in the securities sales business.
Okay.
Yeah. In contrast to our business, which is talking to clients, I'm proud of the fact that I'm able to talk to my clients and give them advice and counsel when they call. Mm-hmm. And I don't have to sell a product to justify my time with them. Mm-hmm. That's true. Eventually in the sales business, the salesperson has to sell a product to justify the time they spend with their customers.
Okay. maybe in this area you can talk a little bit about fiduciary standards and how does that relate to this whole
Yeah,
game?
fiduciary was set up under the 1940 Act. So to earn a FINRA number 7 license, you're under what's called the 1933 Act.
Mm-hmm.
After the Depression, they created several acts which cleaned up the securities business and put regulations into the securities business. And that act was passed in 1933. What they quickly discovered was that qualified plans, pension plans particularly, needed a fiduciary managing the money, not a salesman. So they created in 1940 they passed the act that allowed someone to get a Series 65 license like I have and be a fiduciary for that pension plan. Fiduciary means that they're making the best choices for the benefit of the plan rather than to sell a product. And that relationship means that they are transparent, they need to identify all their conflicts of interest, they never receive a commission, they don't have a vested interest to sell any one product, and they have to have a fiduciary responsibility to their clients, which is different than know your customer standard that the salesperson works under. It's much more in-depth, much higher standard for a fiduciary than for a salesman.
So fiduciary sort of means like acting almost on behalf of somebody.
Good. So yes, a legal term would mean, yes, I'm acting on behalf of my clients. Mm-hmm. I'm responsible for that. I can be held to that level of responsibility. Mm-hmm. Interesting that right at the moment, we're in September 2011 when this show is taped, and Congress in January gave the regulatory agency called the Securities and Exchange Commission mandate that they create 120 different laws.
That's a lot.
That's a lot of laws, and they passed it because they couldn't do it themselves. They passed that mandate on to the SEC, who is a regulatory agency. That we don't vote in people at the SEC. As an American, I think that ought to be illegal, but I'm just one vote. But in the meantime, the SEC is researching how to create the regulation that they need. One of the regulations that they're researching is this fiduciary responsibility.
Yes.
The new law, as mandated from the President Obama, is that they want everyone who gives advice and counsel on financial issues to have a fiduciary responsibility for that client. And I think that's a wonderful goal, but the question is, how do we impose fiduciary responsibility on a salesperson? Mm-hmm. When I was selling product 25, 35 years ago, it was not prudent for me to have fiduciary. I wanted to sell a product. I couldn't sell the product if I had to disclose all my conflicts of interest and find the best product for the client, because the one I was selling may not have been the best product. I would have had to disclose all of my commissions. I certainly didn't want to do that with a lot of my customers. And I would have had to find the best product for my clients, and that didn't fit my sales mentality. So I have nothing against sales. I think the salespeople should be able to sell product anytime they can do that. But it is inappropriate, if not a bad decision, to try and impose fiduciary responsibilities on a salesman. Now, I am mandated by the 1940 Act, as a registered investment advisor to have fiduciary responsibility for my clients. I chose that relationship. Mm-hmm. Clients choose that when they hire me. We work for the client. Remember, we don't work for the big corporations. So I want that fiduciary responsibility, and I want it as broad and as responsibly as it is right now. The risk we suffer as Americans is that the SEC will water down the requirements for fiduciary to something that's closer to the current sales environment, which is simply know your client. If the SEC waters down fiduciary, that means the investing public no longer has access to a fiduciary relationship. They've got something that's been so watered down that it doesn't mean anything. They can't trust the advice and counsel they're getting anymore because that person's not under today's fiduciary standards.
Mm-hmm. So it's kind of a confusing time, and we just have to see how they're going to reconcile, because again, they're functioning, these people, the brokers, in a little different environment, or a considerably different environment from the asset manager, fiduciary, as you are. Okay. Now, aren't there like a range of commissions for different products? And doesn't that range create something? In other words, some commissions are higher as a percentage of what you pay than others, and doesn't that create a little bit of a conflict of interest for the salesperson who's offering those products to the client?
So the example is that if a salesman has a choice between two products to sell, the one with an 8% commission is going to probably get sold more times than the one with the 4% commission would.
You'd think, yeah.
It might be that the 4% commission product is a better product than the 8% commission product, but the salesman's making reasonable choices for himself and the company she works for to sell the higher commission product. Mm-hmm. The investing public suffers from that choice, and without a fiduciary responsibility, the investing public has to research what's being sold. They have to perform their own research so that they know whether the salesperson is selling them the 8% commission product, which might not be as good as the 4% commission product. Mm-hmm. It's interesting to note that 20 plus years ago, I started using a family of mutual funds called Dimensional Fund Advisors. And I performed research on them, and they did things entirely different. They were a mutual fund designed around the practical application of the didactic research out of the University of Chicago. That school is now called Chicago Booth School of Business. Mm-hmm. And we started using that mutual fund family in 1989. All of my clients have that portfolio. It turns out that portfolio has outperformed the stock market and done it with less risk than the stock market, so our performance is in the top 1% of all money managers. That's significant. My story, though, is that the mutual fund, the family of mutual funds called DFA, mm-hmm. would not allow Merrill Lynch, Dean Witter, the brokers, salespeople to sell that mutual fund. You had to be a fee-only advisor, and you had to go to their class and pass it. At the end, they'd give you a test. And if you didn't pass their test, you couldn't sell their mutual funds or represent their mutual funds to your clients. Mm-hmm. So that mutual fund family this year in June became the 6th largest mutual fund family in the world. Mm-hmm. From a minuscule, unknown family of mutual funds to now the 6th largest. So the largest is Vanguard and Fidelity. I don't know, one or two or one, and then 3 more, and then DFA. Mm-hmm. And they were a nobody 20 years, absolutely nobody. Mm-hmm. And only 1,200 fee-only advisors like myself can get access and use those mutual funds for their clients. So just a small cadre of financial advisors have grown this mutual fund family to the 6th largest in the world. Well, for other mutual fund families to compete with DFA, they are increasing their commission payable to the salesman.